Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award winning Compliance Into the Weeds. Welcome back, Matt.
Hello, Tom. Good to be here as always.
Matt, we have returned from Memorial Day to find out the Department of Justice has completely, totally, and utterly caved in to Boeing and are giving them, and I emphasize gifting them, a non prosecution agreement, or at least that's the proposal at this point. You have written about it, obviously, have thought about it, but you want to set the stage and then maybe we can take a deep dive into some of it.
Sure. So this news came out late last week, just before everybody peaced out for the 3-day weekend, that the Justice Department has now decided that it will pursue a non-prosecution agreement with Boeing. That is a stark change in Boeing's circumstances for the better, for Boeing, certainly. This is all stemming from the two crashes it suffered in the late 2010s that killed 346 people with its MAX 737 jets. And that led to a settlement in 2021 that had included a deferred prosecution agreement that would have expired at the beginning of 2024. And just before that DPA expired, we had that blowout of a door on an Alaska Airlines flight, mid-flight. And so that led to everybody to revisit that DPA. The Biden administration's department decided that Boeing had therefore violated that DPA because of the blowout. So that led to more litigation. And they, as of late last fall, were looking at pleading guilty, paying at least $1 billion in fines. I think it was $1.1 billion in fines, and a compliance monitor for 3 years, a 3-year probation agreement, $455 million spent on additional compliance program improvements. That was all there. Then the case got delayed. The settlement at that time got delayed. We can talk about why later on. But so it spilled into the Trump administration, at which point the DOJ said, we don't want to do any of this, really. It's the settlement now is, I describe it as a low-calorie version of what we had been looking at before. No guilty plea, 2 years of an independent compliance consultant as opposed to a compliance monitor, and still the $1.1 billion in fines and other payments. Some of that goes to the 346 victims' families. The $455 million in compliance program improvements, that's still part of it, but no guilty plea, no compliance monitor. We do have a consultant for only 2 years instead of 3. Structurally, it's kind of sort of similar to what we had seen before, but just more, like I said, of a low-calorie version of it. And now we have to see whether the judge and the victims' families will go along with this, which I think is an open question. But this is what we have as of today.
I guess the only thing I would push back on a little bit is I don't think it's low calorie. I think it's no calorie. But other than that, I think that's a pretty fair summary of where we are. You have written about this. You had told us in your blog post you're going to write additional thoughts on this. Maybe we could start with the independent compliance consultant and unpack that a little bit. In conjunction with this, I wanted to take a little bit deeper dive into the recent memo issued by the Department of Justice entitled Memorandum on the Selection of Monitors in Criminal Division Matters. And is this nomenclature simply designed to get around the prescripts laid out in this new memo, or is it something different?
That's the thing, is we don't know. For compliance professionals generally, looking at this case and wondering what does this portend for other businesses, possibly my own, I do think the nature of this independent compliance consultant is the big thing to wonder about. We don't really have much on the scope of this person's duties. It looks like they will be examining the anti-fraud and speak up culture and the ethics program part of Boeing, not the more technical issues around FAA security and whatnot, or FAA standards. The FAA will have technical people monitoring and inspecting Boeing anyways. So this is, like, in many ways, this person is going to serve functionally as a compliance monitor, I think, but we don't know how is this person going to be hired. We're not necessarily clear on how are they going to be paid, how much are they going to be paid. I assume Boeing is going to pay them, but the DOJ policy on monitors, which you just mentioned, that says that the payments to monitors would be capped. This person's pay going to be capped because clearly they must be less than a monitor. Otherwise, they'd just say it's a monitor. Does that mean they would get capped even more? How much is the DOJ going to look at the expenses? How much pushback could Boeing have on this compliance consultant? The only thing we have that is remotely similar to this, Tom, are if people want to remember the off-channel messaging app enforcement craze from the Securities and Exchange Commission against Wall Street banks back in throughout the Biden administration, really. Most of those settlements included independent compliance consultants. Those people, once hired, could not be fired. If you read through the terms of their settlements, the findings of a consultant, really they're recommending things to the banks. The banks had very little discretion to say, no, we're not going to do that. That would have been a big deal with a lot of documentation and pushback before they could resist a compliance consultant's findings. So is that also going to be the case here? I don't know that we had independent compliance consultants as part of DOJ settlements before, but is that really what we're going to see now? And the other thing that, Tom, strikes me, the big takeaway for this is I don't know that we're ever going to see a compliance monitor. Because if we're not going to see one for Boeing and what they did now, when on earth would the department actually think, okay, now we do need a monitor? Like, if not for this, then good Lord, for what? So I would like to see more clarity on the scope of this compliance consultant's duties to help us understand how often are we going to see this. I still think we're going to see them rarely, no matter if they're monitors or consultants or hangers-on of any type. But it's just, that's the thing. That is the interesting part of this settlement, I think, for the compliance community at large.
Your point about monitors, I think that was going to be one of my three key takeaways. I think this portends the end of monitorships, but I wanted to take a deeper dive into the memo and some of the key language I've highlighted, which maybe we can give our thoughts on. Would Boeing even qualify or not under this? And there are two broad considerations to guide prosecutors. Number one, the potential benefits that employing a monitor may have for the corporation and the public, so that there are additional stakeholders here, and that's the public. And then the cost of the monitor and its impact on operations of a corporation. Prosecutors will also assess, quote, the incremental benefits the monitor has above and beyond the requirements imposed on corporate leadership in these resolutions. And the DOJ then goes to specify that a CEO must ask that the compliance program has been effective, or certify rather, and this DOJ seems to think that is a meaningful certification. Additional factors would include any history of recidivism, any interest that might harm U.S. national interests, the availability of other independent government oversight, and you talked about the FAA, and I certainly agree with you on that. But it also says a company's proven history of committing criminal conduct while under such a regulator's supervision is a significant factor and might counsel in favor of imposing a monitor. The additional steps, or rather, the criminal division will evaluate the company's voluntary engagement of a consultant or other third parties. That brings me, and you may be in the process of writing about this, the upgrades or remediation of Boeing's compliance program. And prior to this announcement earlier in May, it was announced that Boeing has a whistleblower program now. And Todd Ha was very complimentary that in 8 years, they've now been able to develop a whistleblower program. And the whistleblower program has the additional safeguard that the person who the incident is reported to does not do the investigation. Previously at Boeing, an employee went to his boss and said something's not right or not safe. The boss did the investigation. You can see where that went. And they're going to have an independent entity do the investigations. And Todd's point was really, this is it. This is what you developed. This is how you've improved your culture. And of course, Boeing crowed about this as an improvement of culture. And so it seems to me that With these factors, I come to the same conclusion as you, except I might even say a little bit stronger. We'll never see a monitor, period. If this case doesn't warrant one, I cannot imagine a set of facts for a company that is going to continue to do business that doesn't exceed or meet all of these guidelines and exceed them in many ways.
I have a couple of thoughts there. First, it's interesting to remember the challenges in front of Boeing for ethics and compliance and safety. When we talked about the $455 million that Boeing has previously committed to spending, I think it was originally over the next 3 years, but now, again, I'm not entirely sure that's still the case, but the amount is there. Spending it on their compliance program to do what? According to last year's proposed settlement, it was expressly to integrate the safety and quality and the ethics and compliance programs into one. I am curious how that would actually function in a whistleblower program that I suspect some portion and possibly a great deal of the complaints that come over a whistleblower hotline at Boeing, they're going to be about quality and safety. And so I certainly appreciate that you need to have an objective analysis of every report, but a lot of ethics and compliance teams would not be qualified really to address ethics and safety issues, or that's not their thing. They're not aviation safety inspectors. I don't know how much they learn about that either formally or through osmosis at Boeing, but it's interesting that we will have what I would call the more traditional ethics and compliance concerns around fraud or cheating or retaliation or something like that. And then these quality and safety issues, which are of sky high importance to a business like Boeing. But I do wonder, how are they supposed to sort all that out? And I had seen, this is something I will probably write about later on, is that just last week, Boeing had published its annual aviation safety progress report. I think that's might even be the formal name of it. But it's clearly yet another one of these reports like that we see. There's a certain genre out there of companies under investigation trying to look like they're taking things seriously. So they publish these progress reports on how they are improving their ethics and compliance program. Boeing's report dwells a lot on building up this whistleblower program. Yes, it should be more independent, but you have to think through, how am I going to staff that out for the probably somewhat unusual types of complaints that a airframe manufacturer like Boeing would actually have? Think about that. Tom, one question I had for you was back to the DOJ policy memo, where you had said the CEO must certify the efficiency or the effectiveness of the compliance program, but the CCO does not need to co-sign that any longer, right? Like, we've had these CCO certification ideas before. I'm assuming from the Trump administration, that's going to go over the side. Do we actually know that is the case?
We don't know that specifically, or there has been no language from the Trump administration, but I would certainly agree with your thoughts on that. The other thing is this independent compliance monitor, two things. An independent compliance consultant, excuse me. Number one, they can recommend to Boeing. Nothing in there that says they can tell Boeing what to do.
Yep.
But there does not appear to be any transparency or accountability. That leads me to another topic you raised, which is there's still a criminal case pending with a judge and with a unique set of victims' rights. And those victims' rights are to be taken into account by law, by the court. And so now we're going to have some type of hearing. What the form of that hearing takes, we don't know at this point, where the court who has lambasted Boeing in no uncertain terms will now decide whether there should be any type of scrutiny over this independent compliance consultant or indeed anything involving Boeing. The victims have clearly made or have made clear to this point they are not in favor of this settlement because they want accountability from Boeing. They wanted it both on the criminal side, which apparently they're never going to get under the Trump administration, but they also wanted it going forward. So no one else had to go through what they've gone through. So any thoughts really on the accountability or transparency of the independent compliance consultant from what we know at this point?
Yes. So we don't know much, and we should be clear that right now the proposal we have runs all of 8 pages. That's it. There's not much there. it may be the case that if this deal does win final approval, we see some sort of more fulsome, longer non-prosecution agreement that would be shared. I would hope so, in the interest of transparency, where we could get more answers about what this independent compliance consultant will or won't be able to do. That is something, going back to the consultant agreements we saw with the Securities and Exchange Commission, they did detail that basically the consultant recommended things, but if the company didn't want to abide by those recommendations, they had to come up with a long and extensive explanation and run it up the flagpole with the Securities and Exchange Commission before they could tell the consultant, no, we're not going to do it. Will that be the case here with Boeing? We don't know. Another thing I've been thinking about a lot is the expanded realm of stakeholders here, because you're right that we do have this hugely important group, two hugely important groups, really. Number one is the victims' families, which have an outsized ability to influence, I think, what the judge would do, and rightly so, because they've suffered such a terrible price. And the other big stakeholder group we have is the flying public, who are not necessarily shareholders at Boeing, but they are deeply distrustful of Boeing, and rightly. Therefore, I've been thinking, what could Boeing do, or what could the Justice Department do if it was serious about trying to win back these stakeholder groups? One thing they could do is publish whatever consulting reports this consultant comes up with. He or she is supposed to come up with some sort of report. I'm not sure if it's an annual thing or just at the end of the 2 years. But whatever this consultant comes up with for improvements, if Boeing were serious about transparency and ethics and trying to win over its stakeholders, they would just shotgun that onto the internet. I don't know that they will. That's almost never happened. Then again, we've almost never had a case as egregious and with so many after effects as what has happened here with Boeing, with planes falling out of the sky and doors blowing out mid-flight. So it would be nice if they actually step forward in that transparency direction. Tom, the other thing that I do want to talk about, though, is how we got here. And we got here because of the federal district court judge in charge of this case, Reed O'Connor, a George W. Bush appointee, who has said that this is a terrible thing that Boeing has done. It looks like he is one of these judges who really did want to hold Boeing accountable, but last fall, when they had that preliminary plea agreement, which was much more severe, O'Connor got hung up on the DEI clauses in the Justice Department's prior corporate monitorship policy. And he wanted to know what that meant. And if we're giving it to somebody who's a minority, does that mean that we've excluded a perfectly good and maybe better white compliance monitor and all this stuff? And hung up on all this anti-DEI nonsense. He put this case on hold to investigate that, invalidated the plea agreement on those grounds, and now we got here. There's a certain bitter irony to what Judge O'Connor has done, is that because he was so obsessed with this remote potential of a DEI monitor and what that may or may not mean, he let us walk away from the chance to hold Boeing more fully accountable. And now he has received exactly what he did not want, or the victims' families, which is a weaker settlement. Shame on him for bringing us here. I don't know what he is going to do now. Most of the time, a federal judge would have to rubber stamp an agreement between these two parties. However, there aren't two parties in this agreement. There's a third party with the families. And you're right that most of them are not happy with this. So I don't know. They've already said that they would litigate this settlement. Maybe O'Connor will not accept it, and maybe things will drag on, which doesn't do the victims' families any good. But nonetheless, there is, as I said, a certain bitter irony that Judge O'Connor brought us here to this point that we didn't need to be at. I don't know what he may or may not do to get us out of it. But, for anybody who's complaining that this is inadequate, how did this happen? Number one, look to the judge. And then number two, look to the Justice Department.
There's one other thing I'd like to bring up, and that's the victims' families here and the victims' rights laws. My third sort of takeaway is this is a huge middle finger to the victims, to the victims' families. They did not consult, they told, consistent with, unfortunately, the DOJ's posture during most of this investigation and litigation. After being scolded by the court over it, the Attorney General himself ordered, or at least had the DOJ sit down with the victims, and there was a lot of press about Glenn Leon and some others meeting with the families of the victims. But here we just basically had the DOJ telling victims' families, leap off, we're going to do this. And I don't think we'll ever, under this administration, there'll be no victims' families who receive anything close to what they receive under the victim rights law. And once again, because of the egregiousness of this case, it simply can't get any worse.
That is fair, yes. We should note that as part of this particular settlement, I think the victims' families are getting $444 million. They've already previously received some settlements per that 2021 agreement. There are still numerous plaintiff lawyers representing them who are saying that is not enough. And I'm not sure how much they really just want money, or do they want to see actual people, Boeing executives or former executives, held accountable criminally? I think they do. Not necessarily opposed to that either, because of the losses that they've suffered and a lot of the terrible neglect and bad practices that went on at Boeing. But it is just sad to see that this department is now going to probably advocate for, I don't even know what the word is here, a feather-light touch to corporate enforcement. But it is what we're going to see. And we're only talking about it now. And there may only be a way away from that today in this case, because there is a victim's families. Their victims' families are a third party to this. They do have some strong legal grounds to speak up in this case. But most of the time, that's not going to be the case. In most corporate settlements, it's going to be the corporation and the Justice Department. The DOJ is clearly not really looking to have compliance monitors ever, probably not looking for corporate guilty pleas ever. And in most occasions, when they reach these settlements, they're going to go to a judge who will have almost no recourse except to rubber stamp it. O'Connor, in this case, does have a bit more recourse. Good, because maybe he could undo some of the mess that he's caused. But we are where we are, and it is just emblematic of what I think is going to be a feathery light touch to corporate enforcement in the Justice Department now.
I guess my only last point would be, no matter how bad your corporation messes up, under this administration, you can buy your way out of it.
Also true.
Matt, maybe we'll have a cheerier topic next week.
Thank you, Tom.
Compliance Podcast Network. Start your mornings with daily compliance news, quick, sharp updates on the top compliance and ethics stories in under 5 minutes every morning in Compliance Podcast Network. Because compliance never sleeps. Need practical advice fast? Check out Compliance Tip of the Day. One actionable idea to level up your program. Short and sweet, every day on Compliance Podcast Network. Got 10 minutes? We've got the week's top 10 stories. 10 for 10 brings you the big compliance headlines. Fast, fun, and focused. Every Saturday on Compliance Podcast Network. And don't miss the Sunday Book Review, where compliance meets culture through must-read books and big ideas every Sunday in Compliance Podcast Network. Whether you're in the office, on a walk, or commuting, stay smart, stay ethical, stay tuned. Only on the Compliance Podcast Network. Available wherever you listen to podcasts.